Task 8 talks about operating as a representative in terms of the FAIS Act. Task 8 has 12 qualifying criteria. Let's look at Task 8, Qualifying Criteria 12. Explain what recourse a debarred representative may have. In Criteria 11, we covered the debarment process and its related sections. In Criteria 12, we will look at the process the debarred representative can take to have the debarment decision reconsidered by the tribunal. We will also discuss the process that takes place for the reappointment of the debarred representative once the requirements that led to the debarment have been met. Let's have a quick recap of Criteria 11 and whether representatives are able to take the decision for reconsideration by the tribunal. Here we can see that once the decision of debarment has been communicated to the representative, then the representative may refer the decision to the tribunal for reconsideration. Under Criteria 12, we will discuss this process in detail. So let's look at Criteria 12, which deals with referring the debarment decision to the tribunal for reconsideration. The FSP will go through the debarment process as discussed in Criteria 11. The FSP will inform and notify the debarred representative of its decision. This notification must include details that the debarred representative has a right to request reasons for the decision and has a right to request the decision to be reconsidered. The FSP has to notify the authority, or also referred to as the Registrar, Commissioner, or FSCA, of the debarment within 5 days. The FSP must also provide the reasons from the debarment within 15 days. It is important to note that the authority does not have any powers to stop or change the debarment by the FSP. The duty of the FSP notifying the authority is more for administrative and compliance monitoring purposes. There are 2 scenarios that can take place. 1. The debarred representative receives the notification of debarment, but no reasons are provided, and it only states that the representative has a right to request the reasons for the decision. Or 2. Reasons are provided with the decision notification. This is important to understand whether the reasons are received and/or included or not, as it affects the timing of taking the decision to the tribunal for reconsideration. Where no reasons are provided with the notification of the decision, the debarred representative has 30 days to request the reasons from the FSP. The FSP then in turn has 30 days to respond and provide the reasons for the decision. Once the representative has received the reasons for debarment and feels aggrieved by the decision of the FSP, they may approach or apply to the tribunal to reconsider the decision. The representative that does not receive reasons initially will have 30 days to lodge the reconsideration of decision with the tribunal once the reasons are provided and received. Therefore, lodging of reconsideration with the tribunal must be done within a maximum of 90 days from receiving the first notification. Where the representative receives reasons with the initial notification, then they will have 60 days to lodge their request for reconsideration with the tribunal. So it is important to note, there is a slight difference in timing depending when the reasons for debarment are received. The tribunal is established by the registrar for a panel hearing to reconsider the decisions taken by the FSP. The tribunal must be independent, impartial, and perform its duties in accordance with the Acts and financial sector laws. The tribunal will hold a panel hearing where all parties are able to attend with a legal representative should they wish to have one. The panel hearing is a public hearing that the general public can also attend. The chairman of the panel facilitates the conduct of the hearing and determines the procedures of the hearing based on the law and tribunal rules. The procedures of the panel are conducted with little or less formality and technicality as allowed by the law in order to perform their duties as fast as possible. The panel is not bound by rules of evidence. Therefore, there will not be formalities of what and how information is presented as it applies in a court of law. The chairperson may order witnesses to appear before the panel and administer an oath that witness accepts to give evidence. The witness has the same protections and liabilities as a witness giving evidence in court. The panel will make one of three possible decisions. 1. The tribunal may set aside the decision to debar and send it back to the decision maker for further consideration. 2. The tribunal may set aside the decision to debar and replace the decision with that of the tribunal. 3. The tribunal may dismiss the application because it's considered frivolous, trivial, done to frustrate the process, or upholding the existing decision. An application may be made to the court to certify a copy of the tribunal's order, therefore making it a civil judgment and enforceable by court. Any party that is not happy and/or satisfied with the decision or order of the tribunal can take the decision for judicial review. Here we can see the overview of the whole process followed when taking a decision of debarment to the tribunal for reconsideration of decision. Criteria 12 then also covers what will happen when the representative wants to be reappointed as a representative after being debarred. To pick up from the debarment process. Remember, the FSP that debarred the representative would remove the representative from its representative register and would also inform and notify the authority of the debarment within 5 days of the debarment. The FSP would also have to provide the authority with the reasons for the debarment within 15 days. This was covered previously. The authority will maintain a debarment representatives register where the representative will remain on until he or she has been reappointed by another FSP, at which time his or her name can be removed. The FSP that is reappointing the debarred representative has all the powers for the reappointment, and it has nothing to do with the authority. The registrar just needs to be informed and notified in order to update its central representative register and monitor compliance with the Act. This is an important concept to understand, that the registrar deals with issuing the FSP with a license, but with that, the FSP is given the power to appoint and debar representatives. The registrar plays an administrative role when dealing with debarment from the authorized FSPs. In order for the debarred representative to be reappointed, the following requirements must be met. At least 12 months since the debarment date. There is, however, an exception to this where the debarment has to do with not obtaining a qualification or with personal characteristics of honesty and integrity. In these cases, if it can be shown that the debarred person has obtained the required qualification or can be proven a change in personal characteristics has taken place, then the period may be less than 12 months. Any unfinished business as a former representative has been concluded. All complaints, legal proceedings have been resolved or concluded, and the applicant has fully complied with the decisions and court order issued. All fit and proper requirements are complied with. Once the reappointing FSP is satisfied that the debarred representative has complied with all the requirements and appoints them as a representative, they will update their representative register. The representative register must be submitted to the authority for updating to the central register. The debarred representative will remain on the debarred register until the person is removed and placed on the central representative register. This is to ensure that the reappointing FSP can check if the representative has ever been debarred before, to ensure that they obtain all the required documents before making a decision to appoint the debarred representative. The reappointing FSP will need to provide the authority with evidence supporting the appointment, which is in line with the requirements already highlighted. 1. An affidavit from the reappointed representative confirming that they meet all the requirements to be reappointed and complies with the fit and proper requirements. 2. An affidavit from the reappointed representative if they were debarred due to lack of honesty or integrity, stating the reasons for reform and rehabilitation. 3. Any other information and/or documents considered by the FSP in the appointment of the debarred representative. 4. Confirmation from a key individual of the FSP that they are satisfied that the representative complied with the requirements to be reappointed. Here is an overview of the reappointment process of a debarred representative. We have gone through the recourse a debarred representative will have. Let's take a look at some questions to test your knowledge. Question 1. Nozipho was debarred 8 months ago due to incompetence and has applied for reappointment at another financial service provider. You advise her that her debarment can only be lifted when A. 8 months have lapsed since the debarment date and all unconcluded business has been properly concluded. B. 12 months have lapsed since the debarment date, but not all fit and proper requirements have been met. C. Qualification criteria has been achieved and some fit and proper requirements have been met. D. Full competence has been achieved and all other fit and proper requirements have been met. So one of the first things you must always do when answering a multiple choice question like this is to remove the obvious wrong answers and then, based on what's left, choose the most correct. So based on the above, we can see that option B says 12 months have lapsed, which we know is one of the requirements. But then it says not all the fit and proper requirements have been met. Therefore, we can exclude that option. Then we see that option C says that the qualification criteria have been achieved and only some of the fit and proper requirements. And we know that all of the fit and proper requirements need to be met as per the requirements learned earlier. Now we are left with A and D. If we look at option A, we know that the time period can be shorter than 12 months if it relates to obtaining qualification, which is not indicated in the answer. Therefore, this would not be the most correct answer. Therefore, option D would be the most correct answer out of those provided. Question 2. Eric was debarred as a representative by Victory Life Insurers 18 months ago. He now meets all the fit and proper requirements. What will Eric's situation be now? A. Eric may now be reappointed if all his previous unconcluded business has been properly concluded and if any client complains, legal or administrative proceedings in any court before the Ombud or in terms of any legislation relating to his actions before debarment have been concluded and he has fully complied with any decision or court order. B. Eric may now be reappointed if all his previous unconcluded business has been properly concluded. C. Eric may now be reappointed. D. Eric may now be reappointed if any client complains, legal or administrative proceedings in any court before the Ombud or in terms of any legislation relating to his actions before debarment have been concluded and he has fully complied with any decision or court order. So before we look at the answer, let's go back to what we have learned about reappointments. We therefore must take a look at the requirements for a debarred representative to meet before they can be reappointed. So we know from the question that 18 months has lapsed from when Eric was debarred, so we can check off that requirement. Now we can see that there has to be 3 other requirements, being 1. Any unconcluded business as a former representative has been concluded. And 2. All complaints, legal proceedings have been resolved or concluded and the applicant has fully complied with all decisions and the court orders issued. And 3. All fit and proper requirements are complied with. So now, based on this information, which of the answers provided best covers these requirements? So if we look at the options we have available, they all say he can be reappointed, but then have additional requirements. Therefore, we know that option C can't be the best option, as this basically just says Eric can be reappointed. And then we have option A, which is just a combination of B and D. Therefore, if option A is all correct, then it would make it the better option than B or D. It is important to note that one of the requirements is that the debarred representative also meets the fit and proper requirements. This was not included in any of the options in this question. Therefore, take note that in multiple choice type questions, it is a process of figuring out what is the best option out of those presented and not always which is 100% complete. Question 3. Any person aggrieved by the decision of FSP to debar may apply for recourse to the Tribunal, Commissioner, Ombudsman, or Prudential Authority. Hopefully this one was easy after going through the material. The Tribunal is established by the Commissioner to deal with the reconsiderations of decisions of the FSP. Question 4. Choose the correct statement. Which is a condition for the reappointment of a representative after debarment if the cause for debarment was for a cause other than a lack of competence? A. 6 months must have elapsed since the debarment date. B. Only the fit and proper requirement of competency must have been met. C. 12 months must have elapsed since the date of debarment. D. Only the fit and proper requirement of honesty and integrity must have been met. So the correct answer is C. 12 months must have elapsed since the date of debarment. Did you get the answer right? Here it is important to remember that the first requirement for reappointment was that 12 months must have passed, and only when dealing with obtaining a qualification can the time be less. With options B and D, it says fit and proper for only certain elements, such as competency or honesty and integrity, but the requirement is that the debarred representative must comply with fit and proper requirements, and does not say only specific elements of the fit and proper requirements. Question 5. The FSP must provide reasons for the debarment to the authority within how many days? 5 days, 30 days, 15 days, at the same time as informing the representative of the debarment. The correct answer is option C, 15 days. Option A of 5 days is the time period within which the FSP has to provide a notification of the debarment to the authority, but not the reasons. Option B of 30 days is the time period within which the FSP must provide reasons to the debarred representatives upon request of reasons from the representatives. So let's go through a final overview of what has been covered. The debarment process was covered in detail under Task 8 Criteria 11, and we showed how the process of recourse available to the representative fits into the debarment process. Then we looked at the reconsideration of the debarment decision by the tribunal and the possible outcomes. Finally, we covered the reappointment process of a debarred representative. Make sure you go through the diagrams and understand the flow as well as the requirements. We hope you enjoyed the video and learnt a lot. Please make sure to check out our other RE videos.